This is going to be a short webinar of 1 hour, and I'm excited that some latest developments have taken place. CBDT has issued its first circular of 2025 on 21st January. We'll be discussing that. There was a recent decision by the Delhi Tribunal, wherein aspects of the principal purpose test under the India-Luxembourg Treaty has been discussed. So that is also something that we'll be taking up today. And before that, I'll be giving you an introduction of what the principal purpose test is, some portions of, the commentary, how to interpret that, some important examples that we have, taken from the commentary, which will help us in understanding what it means and what are the practical challenges in applying the principal purpose test. Okay, so I think with this, let us begin with the presentation that is there. Yeah, so this is going to be our agenda for today. We have chosen UN Model Tax Convention specifically. Why? Because the CBDT circular instructs us to look at the UN Model Tax Convention and not the OECD. Now, you may ask me, what's the real difference between UN and OECD Model Tax Convention commentary? So, more than 90-95% would be a replication in the entire commentary, but wherever there's a digression, UN has many digressions from the OECD model. So that is where UN model comes into play. At the same time, under the Article 29, that is the article which deals with limitation of benefits, paragraph 9, which is the one where PPT has been given. So principal purpose test appears as Article 29.9 of the UN as well as OECD Model Tax Convention. The UN Model Tax Convention has literally one example more than what the OECD Model Tax Convention has, and that is also for a reason, because service fee is not a concept under the OECD model. So therefore, this example that is in addition to the OECD model pertains to principal purpose test application in the case of a service fee exemption. Okay, so therefore, you will see UN commentary throughout the slides. Then we'll do a slide comparison between PPT and GAAR, PPT and LOB, PPT and BO. Why do I say small comparison? Because there is nothing great or more to it. If you really read the provisions by yourself, you will yourself also understand the difference between these anti-abuse provisions. Some are general in nature, some are specific in nature. So PPT versus other general anti-abuse rules, and PPT versus other specific anti-abuse rule. Okay, and then we will also see the what does the CBDT circular talk about. Some interpretation issues that at least came to me. Okay, so may not come to all, but that is what that I found certain amount of confusion, at least in my mind. So I will lay it out to you. It may not be true, but obviously the entire views in this presentation are entirely mine. And the last one is the decision that we talked about. Okay. So with this, let us start with this. So what is principal purpose test? So principal purpose test is a provision that is actually a minimum standard which came came out of the BEPS action plans. So action plan 6 is the action plan which deals with principal purpose test. So principal purpose test is a general anti-avoidance rule. It's not a specific one. Okay. So this is some kind of misconception that no, PPT is specific. So that is, so therefore it will have, preference over the other general anti-abuse rule, maybe GAAR, but that's not the point. PPT is also general anti-abuse, GAAR is also general anti-abuse. One is under the treaty, one is under the domestic tax law. Okay. So PPT is specific to the treaty. Okay. It has got nothing to do with the domestic tax law per se. If you're abusing the treaty, then PPT will come into play. Now, why I have made an intersection here? The intersection is basically because action plan 6, okay, that gives out a recommendation. So recommendations is that PPT is minimum standard. So when you exceed to the MLI, when you sign up for the MLI, then in that case, PPT is something that needs to be there by default. Okay. Over and over that, if you want to add, yes, you can add simplified and detailed LOB. And if you don't want, that, combination, then you can also have a detailed LOB along with a certain anti-conduit mechanism. Okay, so therefore, when I say that PPT is a minimum standard, yes, it is. Sorry, it is a. Sorry, 1 second. I am not able to mark through my. Give me a moment. Let me please just open my PPT once again. Normally, I have the habit. Yeah, I'm sorry. I think I lost my. Sorry. Oh, my pen is not working. I'm just trying that. Okay. Just one moment. Um, pen is not working. I'll just try that once again. 1 second. Pen is not working. I don't know PPT issue है कि pen issue. ठीक है. ठीक है. Anyway, let me continue without the pen. That's fine. Okay. Sorry, I don't think today we have the benefit of annotation on the screen, because typically I annotate on the screen so that it becomes easier. So let me see if I can do that with my uh, my cursor, if that is possible. No, I don't think so. I think without spending much time on this, let it be. Let us move forward. Okay. So MLI. 1 second. I need to give certain examples. So I really wanted my pen to work. But anyway, let's skip that. I will give examples verbatim. Okay, so MLI is a default option. So yes, sorry, PPT is a default option under MLI. So whenever a country signs up for MLI, PPT is something that comes along with added baggage. So India has opted for PPT and SLOB, that is simplified LOB limitation of benefit test, but the other country also has to have opted for the same provisions, that is PPT and SLOB. Only then, as per the matching concept, there will be simplified LOB under the India's treaties, that is under the synthesized text. But otherwise, if the other country does not opt for, simplified LOB under the covered tax agreement, so it will obviously mention, so say suppose the other country is, US. Hypothetically, US is not, signed up for MLI. So if the other country is US and India has also mentioned, India-US has covered tax agreement, US has also mentioned that, then it becomes a covered tax agreement. And under that, then there will be a matching concept. If both countries opt for similar provisions, only then they will come into play. Otherwise, PPT as a base will independently also come into place in the DTA. Now, this is entire article 29. It looks like one paragraph, but there are so many nuances to it that we'll come to know through the session. So let us read the paragraph in entirety. Okay, notwithstanding the other provisions of this convention, okay, a benefit under this convention shall not be granted in respect of an item of income or capital if it is reasonable to conclude, having regard to all the relevant facts and circumstances, that obtaining the benefit was one of the principal purpose of the arrangement or the transaction that resulted directly indirectly in the benefit, unless it is established that granting that benefit in these circumstances would be in accordance with the object and purpose of the relevant provisions of the convention. we'll try to break that down. Many phrases, many terms are something that we'll have to, you know, examine. First is notwithstanding any provisions of the convention. So irrespective of the benefit that would be given under any particular provision, let's say capital gains tax benefit has been given, irrespective, overriding that, a benefit under this convention shall not be granted. So that particular capital gains article benefit will not be granted when, if it is reasonable to conclude. Okay. So mind this phrase, reasonable to conclude. Conclusively is not the word here. If it is reasonable, okay, there should be a reason to conclude that. So there could be many possibilities. One of the possibility is that, you know, you are using that particular provision of the tax treaty specifically for taking benefit without any economic substance. So therefore, reasonable to conclude, having regard to all relevant facts and circumstances. Okay. So therefore, a holistic picture needs to be taken into account. What is reasonable to conclude? That obtaining the benefit was one of the principal purpose. Okay. Not the only principal purpose, one of the principal purpose. Okay. So a particular, you know, transaction or an arrangement may have many principal purposes. Okay. They may have subsidiary purposes, they may have principal purpose. Now, amongst the principal purposes, one of the principal purpose is obtaining the benefit of this particular provision or the DTA. Then in that case, you know, PPT can apply. Okay. So moving forward, that obtaining the benefit was one of the principal purpose of an arrangement or transaction. So principal purpose of what? It has to be an arrangement or transaction. Okay. So this particular, you know, if you see GAAR and compare it with that, so under section 96, yeah, so this will be 96. It talks about impermissible avoidance arrangement. Okay, so therefore here also you will see the definition of arrangement per se. Under Article 29 also it is arrangement or transaction, but in any case, arrangement includes a transaction. So there we can see some kind of parity between this and GAAR. Arrangement or transaction that indeed resulted in that benefit. Okay. So it's not only the intention that counts, it is the effect that also counts. And conversely, it is not the effect or the consequence of the transaction that counts, that you got the benefit. But did you really have the intention to gain that benefit? So these both factors need to be present. It's not only that, okay, post facto analysis that yes, you got the benefit and this could have been your intention. No, there has to be a reasonable conclusion that this was your intention. Okay. Now, how did you get that benefit, directly or indirectly? Why these words are there? Because if you are part of a arrangement where another person has executed certain step because of which indirectly you got the benefit, okay, even then it will get covered. Okay? What is the savings clause here? Okay, sorry. So, not the right terminology. What is the exclusion here? Unless it is established that granting that benefit in these circumstances would be in accordance with the object and purpose of the relevant provisions of the convention. Okay. Mind you, it is not the object and purpose of the provisions of the entire DTA. Okay. It is only object and purpose of the relevant provision. So we'll come to it which provisions are covered. Okay, so say specifically you are taking benefit of the capital gains article. Specifically, you are taking the benefit of the permanent establishment exclusion article. Okay, Article 5(4). Then those cases, it is specifically the object and purpose of those provisions. Why are those provisions giving an exclusion? Why is there a threshold? In what circumstances, you know, such exemption should have been granted? It's not the entire DTA. Okay. So don't confuse this with the preamble to the DTA. Preamble to the DTA is application for the entire DTA. Whereas principal purpose test is provision by provision. You may be denied the benefit of one provision, but you may also be granted the benefit of another provision. Okay. So this is very, very important. This is limited to a particular provision. Okay. So let us see. Yes. So we have broken, these all points that we referred here into different parts. So let's see the first one. You have to see the purpose in the right context. Okay. So for each and every provision, you may not know what is the legislative thought process. I can't say legislative because this is kind of a negotiation that happens between two countries. So what is the thought process of the competent authority behind signing up for that particular provision? Okay. So in that case, you have to remember that typically a DTA is entered into in order to encourage the cross-border trade and commerce. So therefore, bona fide exchanges of goods and services is something that is encouraged in the entire DTA also, which includes the different articles. PPT is specifically to, restrict arrangements where the principal objective is only and only to secure a more favorable tax treatment. Okay, that is important. Now, benefit under the DTA, which articles? So typically is Article 6 through 22, which are distributive articles, where tax may be reduced, tax may be deferred, tax may be exempted in the source state, refund may be obtained from the source state. So that's also there. So for Article 23, when we talk about Article 23 could be, in the case of the resident state, Article 6 through 22 is typically for, distribute articles between the resident and source state, but 23 is basically for the resident state. So you may ask, Acha, how come the PPT article is applicable for a benefit under 23? So let's say you are obtaining maybe a tax sparing benefit. Okay. Whereas, you could have invested through some other country. Okay. So let's say India, Singapore has a tax sparing benefit. Sorry, we have the, I think, underlying tax credit which is there. So let's take the example of underlying tax credit, whereas some other DTA may not have that. So if you have chosen India, Singapore specifically for outbound investment with this underlying tax credit in mind, then in that case, PPT could be applied there. Okay. So then PPT could be applied by the resident state also. It's not only always the source state. So resident state can apply PPT and deny you the underlying tax credit, stating that yes, you chose this particular jurisdiction specifically to gain access to the underlying tax credit under the India-Singapore DT. Now, why 24 article has been referred? 24 is a non-discrimination article. Now, how can non-discrimination article be ever abused? Because that is an article which actually gives you a benefit. Okay, in circumstances where there is a discrimination. So it stops discrimination either on because of nationality or because of residence or etc. There will be many criteria. So under Article 24, one example that comes to my mind is where, in a triangular situation, the sole state is obliged to relieve the double taxation for a P. Okay, income earned by P. So in that case, there could be some kind of abuse of Article 24, which then PPT can cover here. Okay. Then the concept of arrangement transaction, if you have gone through the provisions of GAAR, then, you will easily understand this. So I'll not spend time on that. Then this we have already seen the first bullet. It must be reasonable to conclude. Okay. Conclusive evidence is not required. Only reasonableness test is there. Okay. Then one of the principal purpose. So an example which is, very beautifully being given under the commentaries. A person may sell a property for various reasons, but if one of the reasons for changing the residence, okay, is to obtain the benefit of the tax convention, okay, then para 7 is basically para 7 of MLI. So that is same as Article 29(9) of the UN or OECD model tax convention, okay. So then para 7 could be applied in that case, even though you have multiple principal purposes such as, for facilitating the sale of the property, you have changed your residence. For reinvestment purposes, you have changed your residence. Because if you see under section 54, 54F, now it is Indian property that you need to reinvest into. So therefore, in order to gain benefit of that, coupled with obviously DTA, because PPT is only a DTA provision. Okay. So if the principal, many principal purposes, one of the principal purpose is only for that, then yes. So simplest example that I can give you is, let's say, so the most famous, capital gains tax exemption, at least which has applicability among individuals, is India UAE. A lot of Indians become expats in UAE. Article 13(5) exempts the mutual fund capital gains in their hands. So let's say, you have become a non-resident and a resident also of India and resident of UAE as per the tax treaty. Only for 1 year. In that 1 year, you sold all your investments. It didn't get taxed at UAE level. Article 13(5) will prevent India from taxing it. If that's your principal purpose of becoming a non-resident of India and gaining access to Article 13(5) of India UEDTA, then the principal purpose test will come in and will, deny you that benefit. So obviously the benefit was from the Indian tax side because source taxation rights are curtailed. In the residence taxation UAE, we all know that capital gains are anyway not exempt. So therefore India will deny you that benefit of Article 13(5). Some examples. So literally, this is example C. So 4, 5 examples if you see in the commentary, which I thought would be relevant and would be of general application, I have pulled out here. So this is a case where, our company, which is a taxpayer of state R, wants to invest and put up a manufacturing plant in other countries. Now it has selected 3 different countries. All 3 different countries have similar level of maturity in terms of, political stability, economic progression, labor force, presence, etc. But one of them has treaty with state R, which is state S. Other factors remaining same, state R, that is ARCO, chooses to invest in state S. Will that attract PPT application or not? So the commentary says no. Why? Because all other factors remaining same. The principal purpose, the purpose, that is the intent and the purpose of the DTA per se, including these provisions that would have been there. So, then whatever subsidiary then distributes dividends, you will get the benefit of the DTA. So this is the basic intent of all these provisions is to encourage legitimate cross-border investment. So therefore, that is the intent for making the investment in status and not the tax treaty. Okay, the tax treaty itself is for encouraging cross-border trade. Okay. So that is the conclusion of example C. Example D. This is kind of a pooling vehicle. So this is an example of a fund. So ARCO is domiciled in state R. It has investments in, it has investors from state R and outside state R also. Now, 15% of the investment it is planning to make in state S, where the DTA withholding tax is reduced to 10%. Only 15% of corpus, not more than that. In this case, can a tax authority state either of S or of R? Okay. So R will obviously say, no, irrespective of, withholding tax reduction, I am going to tax the entire dividends. So therefore, really it will be state S tax authority who may apply the PPT in this situation, and they may say that, you have invested in our country simply because we have a treaty with your country and we have to reduce our withholding tax rate to 10%. Can that be alleged? So the conclusion here is no, that cannot be alleged because one, it is a pooling vehicle. Second, this is one of portfolio companies, only 15% of the investment is there in this country. Okay. It's not more than that. So therefore, it's a legitimate investment call that ARCO would be doing in order to invest in a company of status. Reduction of the withholding tax rate is not the driver of the decision, neither it is one of the principal purpose for investment. Principal purpose is getting returns. Okay. So this example also has some uh, kind of similarity with what the recent Delhi tribunal decision in the case of SCOV has deliberated on. But obviously, they have not referred to this example, but the facts were little similar in this case. Next is the example where, uh, ARCO has always held 24% in ESCO, which is a company of state S. Now, in order to get the benefit of the dividend article, reduction in withholding tax, there is an insertion of the clause which says, no, minimum you have to have 25% shareholding, only then we'll give you the reduction of the withholding tax benefit under state RSDT. So what ARCO does? ARCO additionally invests in 1% in the shareholding, and it makes and brings it to 25%. So from 24% it went on to 25% in order to get the benefit of this dividend article. So the question here is, will this come under the PPT clause or not? Will this get caught under PPT or not? So the answer here is again no. Why? Because 25% threshold is a threshold which is specifically given in order to ensure that yes, there is serious shareholding that is being made in a company of state S. Okay, it is not for the purpose of only obtaining the benefit. So therefore, if you are serious enough, you invest 25% and then we'll give you. So with that intent in mind itself, ARCO made that 1% additional investment. And that's why it is in accordance with the object and purpose of the dividend article itself. So that's why you will get the benefit. Now the last part, this is second last. Okay. This is a case where, they have given an example of setting up of a regional holding company. Regional holding company in state R. Why? Because, state R will have the tax treaties with state X. State T does not have a tax treaty with, is it same? Just one moment. I'll just go through this. In the example, merely reviewing the effects of this intergroup. Yes, okay. So state R has a beneficial tax treaty with state X, and all the group companies that would be there with the different states, state R has a good treaty network. But the decision here, as per the facts, is that I need to make that a regional holding company for, giving intra-group services. Okay, so that means treasury services, management services, legal, admin, etc. Everything would be centralized here. And this state R has the relevant, factors because of which ARCO was chosen to be based in state R. So therefore, it has skilled manpower, reliable legal system, business-friendly environment, political stability, member, regional, etc. So the crux here is that yes, since there is substance in ARCO, obviously ARCO should provide all these services to all the group companies. Only if it does that, then in the context of the investment, getting the treaty benefits is only ancillary. That's not, that cannot be called as one of the principal purpose. And that is why PPT cannot be applied in this case. Okay. And the last article, this is last example, this is coming out of the UN commentary. Okay. So this is not there in the OECD commentary, this is on the UN commentary. And this is also a very simple one. This is kind of an anti-fragmentation clause where if TICO were to do a certain contract with ESCO, then in that case, it would have exceeded 180 days. Okay. So initially, the contract execution took 150 days. Then, it was felt that no, it will take another 90 days. So if I add 150 to 90, that will 240 exceeding 180. So therefore, there will be a service fee then. So what TICO thinks of, for the additional 90 days, let me assign the contract to my group company in state T. So there is a splitting up that is happening. So TCO by itself would be 150, subco will be 90. Both are below 180, both will get the benefit of service fee exemption. So here is where PPT will apply. And in that case, we'll consolidate the number of days and say that no. This is pure, this assignment is with the intention of taking the benefit of service fee exemption, which is not in accordance with the object and the purpose of the service fee exemption. And therefore, we will deny you this benefit. Okay. One ancillary question that comes to my mind is, what if, in order to keep the number of days below 180, what if it increases the number of employees? Okay, instead of keeping it 150 plus 90. So 150 is something that is achievable maybe with 10 employees. What if you employ additional 10 employees? So now it becomes 20 employees. With 20 employees, you are able to keep it below the threshold of 180. Will PPT apply in that case also? Okay, so that's a food for thought which I am placing before you all. I am not going to analyze that. Yes, we'll quickly go to the next slide, which is the comparison of PPT with other anti-abuse provisions. When we come to GAAR, okay, so when you see section 96 specifically talks about where an impermissible avoidance arrangement means an arrangement, the main purpose of which is to obtain a tax benefit. Okay. Whereas when you come to principal purpose is where one of the principal purposes is to obtain that benefit. So therefore, in my view, there is a lot of difference between PPT and GAAR. PPT is much broader. GAAR, specifically, you have to pinpoint that yes, this has to be the main purpose of entering into the arrangement. Whereas principal purpose is, first of all, is reasonable to conclude, and second is one of the principal purposes. Okay, so therefore PPT is much wider. So therefore, I would like to maybe take the view that yes, if an arrangement does not fall under PPT, then it is uh, unlikely that it may fall under GAAR. Okay. Then second one is the comparison between PPT and LOB. Okay. In this case, LOB, so this is actually specifically given in the commentary also. LOB is where it is a general entitlement to the entire treaty. If you are a qualified person, you get the benefit of the DT. If you are not, you don't get the benefit of DTA. So it is for the entire DTA per se versus PPT is for a specific clause of specific article of the DTA. So article by article, you have to apply PPT, whereas LOB is for the entire DTA itself. Now, let's say that you are a listed company. Okay, listed company typically, or an individual also assumed typically to be a qualified person. Not necessary that PPT may not apply to them. Okay, may not be applied to them. A listed company can also engage in abuse transaction, which can come under PPT, and individual also can. Individual, the example that I myself gave of, taking Article 13(5) benefits of the India UAE DTAA. So therefore, LOB is at its own place, PPT is at its own place. The LOB commentary cannot be applied to PPT. The PPT commentary specifically states that whatever guidance that has been given under LOB cannot blindly be applied to the PPT also. The last comparison that I have done is PPT versus beneficial ownership. Okay. How do we compare both? Is it that, when BO applies, PPT cannot be applied, or PPT applies, BO cannot be applied? So BO is typically a term that you will find in dividend interest royalty articles, but it was a subject matter of debate in Tiger Global decision of Delhi High Court, which has now been stayed by the Supreme Court. But just want to bring it to your notice that there was an argument made that BO is implicit in capital gains article also. And a lot of, commentaries of foreign authors, etc. were mentioned. here is where, book of Professor Michael Lang, under whom, I have learned tax, was also referred and stated that BO is only one of the criterias in order to restrict tax abuse, need not be restricted to only those articles. Okay, so it is implicit in other articles too. If we go by that, then if beneficial ownership criteria is not satisfied, then anyway you're not going to get the benefit of that article per se. Okay, so let's say that, I am an Indian company, I'm making payment to a foreign taxpayer or my investor. Now that investor is not the beneficial owner. It has to immediately pass on the income to the UBO. Then in that case, I will not apply the treaty between, India and that investor's country. I'll have to apply the DTA between India and the UBO. So in that case, there is no occasion to apply PPT. Okay. That treaty itself does not apply. There is a question of PPT, so let's say dividend article PPT to be applied from that treaty, because the treaty itself does not apply. Okay. And same goes for LOB, because if you are not a qualified person, you won't get the treaty benefit. If you don't get the treaty benefit, then PPT will not come into play. Okay. So this is the interaction that I wanted to bring out between PPT and the other anti-abuse provisions. Okay. Now let's quickly come to the recent CBDT circular. Okay. So what does the recent CBDT circular say? So CBDT circular, it's a very good measure that this circular has been issued. And it clarifies certain things, but obviously, whenever any provision comes into play and when you dissect it, you try to go into the granularity of it. And that is where, I also have certain doubts. Don't know whether justified or not, but I'll also lay it down before you. Let's first see what the circular says. So circular says that PPT under the DTAs has to be applied prospectively. It is never retrospective. Okay. PPT is always prospective. It's not retrospective. We'll compare that with GAAR also. Okay. Then second, what it says is that if there are grandfathering provisions under certain treaties like, India-Cyprus, India-Mauritius, India-Singapore. Okay. So Article 13 with effect from 1st, April 2017. So there was grandfathering for all investments that were made before that. Then how will PPT interact with that? So it specifically says that no. PPT will not apply to the treaty commitments that we have made with those countries. Okay. So we will not apply PPT in order to deny them. Okay. So how that will also play out, we will look into that. And the third one is, if I have any doubt for application of PPT, where do I look for? I have to look for in the UN model tax commentary, web section plan, commentary also, which is actually reproduced in UN model with an addition of that example N that was there. And also take into account India's reservations. So that is something that is very surprising, because there is no concept of reservation under the UN model. The concept of reservation is only under the OECD model. Okay. And if the CBDT asks me to look at UN model, where is the question of applying reservations after all? And in any case, for PPT in OECD model also, there is no reservation of India. Reservation of India for LOBs for Article 29(4), which is something else, derivative benefits. It's not for PPT. So therefore, I'm little surprised why, they have mentioned about taking into account India's reservations also. Okay. So for prospective versus retrospective, I think we have a specific slide. Then also for how it will interact with grandfathering provisions, that also we have specific slides. So let's go into it. Okay. So prospective versus retrospective. Okay. So here is where, this is so when I told that, we need to go into the granularity of it. So here is where we have done a deep dive at our office. And here is where we found certain inconsistencies, if I may call it, because that is coming from my perspective, my understanding of the subject. So there are different stages of a DTA and a protocol. Okay, negotiation happens, then internal procedures are there, then you have to intimate the other country's competent authority that yes, we have completed internal procedures, after which date of entry into force comes into play, after which date of entry into effect comes into play, and now additional factor of notification also because of Supreme Court decision in case of Nestle. Okay. So let's start with the Supreme Court decision first. So Supreme Court decision specifically says that a specific notification, separate notification is necessary and is mandatory in order to give effect to a new DTA or a new protocol. Okay. Simply because, you have signed a particular protocol need not make it applicable. Neither does the date of entry into force make it applicable. Neither does the date of entry into effect make it applicable. But the date of notification makes it applicable. Unless the notification says that, yes, this is not the date which we have in mind in order to make it applicable. Just like if you see India-Swiss DTA, India-Swiss DTA, the notification specifically gives a date when it would come into effect. Okay. Otherwise, typically date of notification is considered as the date of applicability. Okay. So here is where my confusion is. Let's take the example of India-Chile DTA. Date of entry into force is 19th October 2022. Date of entry into effect is 1st April 2023. And date of the notification by CBDT is 3rd May 2023. Now, the Supreme Court decision tells me that yes, I have to consider the date of notification. Whereas the circular, CBDT circular, which we saw in the previous slide, here it says that it will come into, so it will be applied prospective. From which date? From the date of entry into force. So as per the circular 1 of 2025, I have to apply 19th October 2022. Whereas the protocol itself tells me that the date of entry into effect will be 1st April 2023. And now the Supreme Court tells me no, the notification date, notification is mandatory. So therefore, unless you have the notification in place, you cannot apply the provisions of protocol. So Supreme Court decision tells me it has to be 3rd May 2023. Now, let's try to analyze this practically. Let's say there is a arrangement or a transaction, okay, that has taken place before 19th October 2022. But the tax benefit in that respect is arising as on today. Okay. So today is 30th January 2025. In that case, what will happen? If I go as per the CBDT circular, it says it has to be applied prospectively after the date of entry into force. So 19th October 2022. Whether I can apply PPT in that respect, it says prospective. So prospective is for the benefit or prospective is for the date of entering into that arrangement. In my view, if I even look at, the GAAR provisions rule 10U2, there it specifically says that acha, with effect from 1/4/2017, even a tax benefit arises after that in respect of arrangement entered into, at any point in time, then GAAR provisions will apply. And that is rightly so because you are planning to cover the tax benefit there. Here you are planning to cover the benefit arising out of the DTA. But one may say that no, then what is the, what is the meaning of prospective? So if you say that any benefit arising as on today will get covered, then what is the meaning of prospective from 19th October 2022? So in my view, prospective meaning the benefit that arises after any of the dates that will, you can consider here and not before that. Let's take another example. Another example is that the arrangement has been entered into after 19th October 2022, but before 1st April 2023. So December 22 is the arrangement date and income also arises say in January only, in 1 month only. Okay. So calendar year difference in one calendar year I entered into arrangement, next calendar year, I immediately got the benefit. That case, will PPT apply? My view is no. PPT will not apply because you have to see at least the later of the date between entry into force and the entry into effect. So there, should I consider the entry into effect as 1st April 2023 or 3rd May 2023? In my view now, because Supreme Court is very clear, you cannot consider even 1st April 2023. There was a delay in issuing notification. As per the Supreme Court, you have to take into account 3rd May 2023. Now, the most interesting situation is, let's say that my arrangement was also entered into in 10th April 2023, and the tax benefit or the benefit of the article also I want to claim on 20th April 2020. Both have happened between this period of entry into effect as per the protocol and the date of notification of the protocol by CBDT. In this case, what is to be done? Can I say that, PPT can be applied or it cannot be applied? So these are certain permutations, combinations that can come up. Obviously, only in cases where there is a delay in issuing of the notification. Just like, for MLI. Let's take the example of India, Singapore. The MLI, CBDT was very proactive. The notification was issued in 9th August 2019 itself, even before the date of entry into force. So here, obviously, this kind of confusion can never come up. Only in some cases, where there is a mismatch in the dates, etc., some kind of confusion can come up. This becomes very, very clear when you read the 2011 protocol of India-Swiss DTAA. Their signing, so typically what the date of entry into effect, provision says that the financial year succeeding the year of completion of the procedures, that means the entry into force, that is the financial year from which the provision should apply. But here in India, Swiss, it says no, not the financial year succeeding the year of date of entry into force. It is financial year succeeding the date of signing of the protocol. This is specifically in respect of Article 26 that I have mentioned here. So India-Swiss Article 26, exchange of information. They wanted to have immediate effect for exchange of information, so that would have been mutually agreed. So signing date was August 2010. Date of entry into force was October 2011. Date of entry into effect was April 2011, though the notification was issued in December 2011. Here the notification specifically says that yes, for Article 26 to come into play, the date of entry will be 1st April only. Okay, so here retrospectivity was actually factored in and was listed in the notification itself, where it is not listed, let's say India, Chile. So there, it will not be retrospective from 1st April, but it will be prospective from 3rd May. But again, coming back to our original question, the CBDT circular says prospective from date of entry into force, which in my view, they have liberally used the term date of entry into force, but none of the provisions of the DTAA protocol ever, come into play from date of entry into force. It is always from the date of entry into effect. Okay. So I think loosely they have used, but if you see the intent, it is typically the date of entry into effect, and now modify that with the Supreme Court decision requirement of issuing a notification. So it will be the date of entry into notification. Okay. So this is the kind of interplay between these concepts, date of entry into force, date of entry into effect, and the CBDT notification that at least came to my mind, which I wanted to bring forth. Now, when the circular says that no, if we have given some bilateral commitment, then the PPT should not apply to that. So therefore, what you have done is we have presented what is the benefit under the particular provision. Article 13 gave the benefit that shares acquired before 2017, and if you sell it off at any point in time, there will be grandfathering of capital gains benefit. If it is between 17 and 19, then 50% tax benefit, etc. That was there. Now, in order to gain the benefit of Article A, and 4B. 4C has not been given here, but 4C is also there, the between, 17 and 19. In that case, you have to satisfy the LOB provision which is there under Article 24A. So though the circular says that PPT provision will not apply to the bilateral commitment. So effectively, it is grandfathering the benefit from PPT. But obviously, the corresponding LOB has to be satisfied. Whether or not PPT applies is okay, but Article 24 still needs to be satisfied. So grandfathering is not kind of blanket benefit that has been given. You still need to satisfy the provisions of the respective LOB. Now under India-Mauritius, the proposed PPT is so that protocol has been signed. It has not come into force. It has not come into effect. Now, if you see here, is it being given? Yeah. So, for date of application of India-Mauritius, it says that the provision of the protocol shall have effect from the date of entry into force of the protocol without regard to the date on which taxes are levied or taxable years to which the taxes relate. Now, this text was a little bit confusing because if you read the second part of the sentence, without regard to the date on which the taxes are levied or the taxable years. So let's say if the taxable years relate to, 2020. The protocol has been signed now. Okay. Can it apply to a 2020 arrangement? So retrospectivity was a question mark under the India-Mauritius DTAA, but now because of the new circular is a beneficial provision. Circular says no prospective from the date of protocol, from the date of force. Okay. So therefore, retrospectivity, all those doubts with respect to the proposed PPT text are done away with because now circular number 1 is very clear. It will apply prospectively. Okay. So this was with regard to India-Mauritius. Now, I think the last thing that we'll cover is the recent decision. This was a decision in the context of India-Luxembourg DTAA. So this was again a fund, FPI 2 category, registered with SEBI, which was organized in Luxembourg and then invested in Indian securities. So it got interest income also, it got capital gains income also. So the AO alleged that, you are, originally the UBO is a Cayman Island company. Why are you coming through Luxembourg? Therefore, you are coming through Luxembourg in only and only to get the benefit of the DTA between India and Luxembourg. Okay. So here is where, the taxpayer placed a lot of arguments which said, I was incorporated way back in 2015. It is not only India investments, it is investment world across. India investments is only 14%, 86% is outside India. Okay. This is a special purpose vehicle. I have filed and paid taxes in Luxembourg. Okay. Etc. etc. And there is substance also in Luxembourg. On this basis, the tribunal ruled that yes, the taxpayer has proved that yes, it is an entity which has paid taxes in Luxembourg, which is a pooling vehicle. It is a SDS for making further investments. Beyond India also, there are a lot of jurisdictions where they have made investments. So therefore, one of the principal purpose was not for taking the India Luxembourg benefit. Obviously, it also relied on the decision of Tiger Global, but that was primarily in the case of TRC. So, Tiger Global had mentioned a lot about TRC, LOB, etc. And also about GAAR. There it had mentioned that, GAAR can actually come into play after satisfaction of LOB. GAAR can come into play only in cases of abuse, extreme. So there has to be tax evasion and, some of the serious consequences that are there. Otherwise, GAAR cannot be applied. TRC there was taken to be sacrosanct, but that decision has been stayed. But the factors here that guided the tribunal in order to arrive at the decision that yes, PPT has not been failed. Okay. So it was basically the substance that was shown and a holistic analysis. Okay. So again, the terms here are having regard to all relevant facts and circumstances. Okay. So on a holistic analysis, it concluded that yes, PPT has been satisfied. You cannot deny the treaty benefit. And again, the A also failed to provide evidence to the contrary, that it was a conduit, etc. Okay. It was legitimate entity. There was expenditure, legal expenditure was there, consulting was there, administrative, operational, etc. So therefore, you cannot deny the benefit. So I think with this, we come to an end of the presentation. So one suggestion that, the commentary makes, the commentary itself states that, this is a provision where, the UN model itself says that it involves an element of uncertainty. TPTEC, because one may say it is objective, but at the end of it, it's not an objective test. It is subjective because you have to take into account the entire facts and circumstances of the case. So therefore, in order to give certainty to taxpayers under GAAR, just like we have a panel. The commentary itself suggests that many countries have panel consisting of senior officers, etc., independent panel, where they can review any allegation of general anti-abuse rules. Similar can also be proposed for PPT. So my recommendation would be that yes, uh, like the GAAR panel, any and every contention of application of the PPT article to deny tax benefits should go through the GAAR panel, so that a holistic analysis and a proper application of collective minds can be done in that case. So I think with this we end the presentation. Obviously, I would like to acknowledge contribution of my colleagues Naisa and Nishita. They have put in a great deal of hard work to prepare this presentation in a very short span of time. Okay, so therefore, because of them, we are able to get the benefit of this presentation. If we have some time, then seems there are some questions. So can we take that up, or we are out of time and we can, they can connect with me offline. I leave it to you, Taxman, whatever you say.
Sir, I don't see a lot of questions. If you wish to take them right now,
Okay, okay.
please go ahead.
So one question, at the time of payment to NR, we deduct TDS under the DTA at lower rate. In such case, do we need to take declaration about PPT clause? Certainly, yes. And in case of deviation, whether tax office can ask to pay TDS differential? Yeah. So, I mean, 201 provisions, etc. So those are very common. So therefore, nowadays, whatever, so you may be taking no P declaration, etc. But you also have to now take, satisfaction of PPT clause declaration also. So that is always a good practice. Then another provision, will PPT apply over Article 8 when the contracting state also exempts such income? Yes. So PPT can apply to any provision, just like we saw Article 6 through 22, even 23 and 24. So that includes Article 8 also. So if the facts suggest that yes, a particular ship has its registered office in a country where Article 8 with India has beneficial provisions, then yes, you will have to prove to the otherwise. Okay, then so we have answered. Okay, so I think there is one more question. Need clarification regarding UAE LLC taxation for sole owner working from India. I requested this. Sorry, I am actually not able to understand this, but we can take this offline. You can connect with me, and or maybe you can type in your question if you still want. But I'm sorry, I'm not able to understand your question. So, if there are any more questions, please do put in the chat box. Otherwise, I think we can uh, come to the conclusion of this session. We'll wait for 10 seconds. If there are any questions, please put up. Yes.